purpose of this session is to discuss some of the more recent developments in the law in relation to causation in both victimisation and whistleblowing claims. You can see that there are 3 recent cases that have appeared, EAT decisions, that have appeared across the course of this year that I'm going to go through in due course. But before I do that, I think it'll be helpful to perhaps remind ourselves of how the law has developed in this area, to touch on some of the similarities and the differences in the court's approach to, and the tribunal's approach to, the question of causation. But as we do that, a bit of a note of caution. The last case on the list there from, I think that was from May of this year, First Greater Western and Musa. What the EAT pointed out there, in particular Mr. Justice Kerr, said was that the cases in this area have not developed in an orderly or uniform progression. And so from my perspective, I think we have a long way to go before we do achieve a consistent and clear approach in relation to the question of causation. So in terms of these overlapping causes of action, we see in the slide there victimisation, protected disclosure dismissals, protected disclosure detriment, and of course, at the centre of any dismissal case is the ordinary unfair dismissal provisions in section 98. And undoubtedly, significant similarities exist between the concepts of victimisation and protected disclosure detriment or dismissal. And in fact, the long title, in terms of the terminology in the primary legislation, the long title of the Public Interest Disclosure Act is an act which, among other things, allows such individuals to bring an action in respect of victimisation when disclosures are made in the public interest. But aside from the terminology, we'll all be familiar in our own practices that there are factual similarities between allegations of victimisation and protected disclosure claims. I'm an employee. I complain about something in the workplace, perhaps discrimination or unconscious bias against women. As a consequence of that, my boss or my colleagues treat me badly. And I say that was either because I did a protected act, I asserted my rights under the Equality Act, or because I made a protected disclosure. I disclosed information that I believed tended to show that my employer was in breach of its obligations to myself as a woman and to other women in the workplace under the Equality Act. So there are similarities without doubt, but of course, having said all that, there are still significant differences between the 2 causes of action, and across recent years, the courts have struggled with the extent to which it's proper to rely on case law authorities and perhaps victimisation claims when interpreting the whistleblowing provisions in the Employment Rights Act. And the start point, as always, should be the primary legislation, because there are differences. Who is protected? Who can be liable? Where does the burden of proof lie in establishing in a dismissal case, for example, the reason for the prohibited conduct or a dismissal? And when does that burden of proof apply? Does it stick with one party throughout, or does it shift depending on whether a prima facie case is established? And in answering those questions, if we start with the Employment Rights Act, we know that it is the right not to be unfairly dismissed rests with the employee, as opposed to the kind of wider remit under the Equality Act. And it's for the employer to show the reason, or if more than one, the principal reason for dismissal. In terms of whistleblowing, the Public Interest Disclosure Act introduced amendments to the Employment Rights Act with the introduction of Section 103A, the protection against dismissal for having made a protected disclosure, and its corresponding provision, Section 47B, in relation to detriment. Then, around a decade or so later, the Equality Act is introduced, offering wider scope for protection of workers, and importantly, allowing for vicarious liability on employees for the actions of their employees or agents, subject, of course, to the statutory defence, and individual liability for specific employees. And then finally, in terms of the primary legislation, the Enterprise and Regulatory Reform Act in 2013 extended the employer's liability in respect of whistleblowing even further with the introduction of Section 47B 1A to 1E, extended liability for workers and agents in relation to whistleblowing. So I'm going to go on to discuss some specific cases in a moment. But what I will say is in relation to the overlap between victimisation and whistleblowing, it's clear that the courts have found it a lot easier to find similarities when it comes to interpreting what a detriment is than it has when it comes to look at causation or the reason for the detrimental treatment or the dismissal. So I guess, first of all, why has the issue of detriment not proven to be particularly problematic? The obvious answer is that it's described in exactly the same way in both the Equality Act and in the Employment Rights Act. Under Section 27 of the Equality Act, a person A victimises another person B if A subjects B to detriment because of a protected act. Similarly, in Section 47B of the Employment Rights Act, when it comes to whistleblowing, a worker has the right not to be subjected to detriment because of a protected disclosure. And there are a couple of cases that have dealt with the issue of detriment. The first being we're looking at is a pre-Equality Act case, Woodward and Abbey National PLC. And in that case, the Court of Appeal held that detriment in a protected disclosure case should be construed in line with the principles applied to victimisation claims. Lord Justice Ward, lovely man, said, although the language and the framework might be slightly different, it seems to me that the four acts are dealing with the same concept, namely protecting the employee from detriment being done to him in retaliation for his sex, race, disability, or whistleblowing. And that, of course, was reinforced relatively recently in Tiplady and the City of Bradford Metropolitan District Council in 2020. What is said in the context of detriment is that Parliament must be taken to have intended, when using the terminology of detriment in the discrimination legislation and in Part 5 of the 1996 Act, that it should have the same scope in both. So it's now fairly settled that detriment is to be treated in exactly the same way, whether you're talking about a discrimination claim or a whistleblowing claim. But why have the courts struggled with looking at the similarities in respect of causation and assessing the reason why question? Why has that become so much more difficult to navigate? Well, the first reason I would suggest is the difference in terms of the burden of proof provisions. Of course, as we've already discussed, under the Employment Rights Act, if we're talking about dismissal, the burden is on the employer to prove the reason, or if more than one reason, the principal reason for dismissal, and contrast that, of course, with the shifting burden of proof provisions in the Equality Act when one considers victimisation. And the way in which those two things rub against each other was considered in the case of Kuzel and Roche, which is on the slide there, and is detailed in a bit more detail in your handouts. That was an automatic unfair dismissal claim on the grounds of the claimant of having made a protected disclosure. Now, at first instance, the Employment Tribunal found that the dismissal was unfair for procedural reasons, and they also found that Roche hadn't got over that burden of proof in establishing the potentially fair reason for dismissal. Nevertheless, it dismissed the claimant's claim that she was dismissed because she made a protected disclosure. On appeal, on the claimant's appeal to the EAT allowed the appeal, saying that they felt that the tribunal had erred in imposing the burden of proof on the claimant to prove that she'd been dismissed for a protected disclosure. And there was some suggestion before the EAT, although this wasn't repeated in the Court of Appeal, there was some suggestion in the EAT that the burden of proof in protected disclosure cases should be the same as in discrimination claims. The matter was remitted by the EAT back down to the tribunal. The claimant appealed that decision to remit, wanting instead a decision substituted, and Roche cross-appealed on the basis that firstly they said the burden of proving that the dismissal was because of a protected disclosure fell on the claimant, but even if they were wrong on that, the tribunal was still entitled to find that the reason for dismissal was not, as the claimant asserted, was not because of a protected disclosure. And the Court of Appeal agreed with Roche on the cross-appeal, and giving the leading judgment in that case, Lord Justice Mummery warned against this cross-fertilisation between the concepts of victimisation and whistleblowing. And in fact, in relation to the burden of proof, he said that submissions show how worked up lawyers can get about something like the burden of proof. It's not normally a problem in most areas of civil law, but made the point that discrimination law is a very different animal. Ultimately, what the Court of Appeal said is that the legal burden to prove the reason for dismissal was on the employer, and in this case, the employer's reason was rejected by the tribunal, but it doesn't automatically follow that the tribunal has to find that it must be the alternative reason advanced by the claimant. It was perfectly open to the tribunal to reject both contentions. And the Court of Appeal took things back to first principles. Effectively, he who asserts must prove. The claimant didn't prove facts on an evidential basis to support her claim for unfair dismissal on the grounds of having made a protected disclosure. The second reason why, and probably the one you're most familiar with, why causation has proved to be such a problem in relation to victimisation and whistleblowing, is in those tainted information or Iago cases. Iago, of course, being the villain of the piece in Othello, whispering false accusations about infidelity into Othello's ear. And this has caused a particular complication in cases involving dismissal, because remember, the burden of proving the reason for dismissal rests with the employer, and in analysing that reason why, the tribunal has to apply the test in Abernethy and Mott, Hay and Anderson, looking at the set of facts known to the employer, or as it may be, of beliefs held by him which caused him to dismiss the employee. And of course, the reason that's caused a problem is people or employers who make decision makers who act in good faith, who have no knowledge of any protected disclosures, but are either misled or are given information which unwittingly leads them to sack someone or subject them to detriment. And this issue arose in two cases that you will, I'm sure, be familiar with. In the context of discrimination, Reynolds from 2015, and in the context of whistleblowing, Royal Mail and Duty from 2019. Now, in Reynolds, the discrimination case, the claimant had lost her age discrimination claim at first instance, and on appeal, the Employment Appeal Tribunal said that the tribunal should have taken into account the mental processes of other people who'd influenced the decision to terminate her employment. But the Court of Appeal said no, and Lord Justice Underwood, rejecting this composite approach, combining the Decision Makers Act with somebody else's motivation in favour of a separate acts approach. And so that was the position established by as I say, the Court of Appeal in Reynolds, more recently confirmed and reinforced in Alcida Orange and Ferridge Gunn last year, 2023. But there was a deviation from that, of course, in the later case of Royal Mail and Duty, and that was a whistleblowing case. So this is where the paths diverge, if you like, between whistleblowing and discrimination in relation to causation. I won't rehearse the facts of that case, but the Employment Tribunal had originally dismissed the claim on the basis that they could only consider the motivation of the decision maker and not anyone else who influenced it. The Employment Appeal Tribunal allowed the claimant's appeal and adopted a wider approach, but the Court of Appeal then reversed that decision and went back to first principles, the reason for dismissal, section 98, and the test in Abernethy and Mott, and said that for the purposes of determining the reason for dismissal under section 98(1), the tribunal was only obliged to consider the mental processes of the decision maker themselves, subject to limited exceptions. Now, in the Court of Appeal, those limited exceptions were somebody in a more senior position, potentially to the claimant who could, and the decision maker who could have influenced matters. And then when this finally went up to the Supreme Court, the issue before the Supreme Court was whether, in a claim for unfair dismissal, the reason for the dismissal can be other than that is given to the employee by the decision maker. And the Supreme Court said yes, that could be the case. It was the court's duty to penetrate through the invention rather than to allow it to infect its own determination. And importantly said, if a person in the hierarchy of responsibility above the employee determines that for reason A, i.e. making protected disclosures, the employee should be dismissed, but that reason A should be hidden behind an invented reason, that's where it was the court's duty to look through that invention. So the net result at present is that there is that divergence. So you have a restrictive interpretation in terms of the reason why question in discrimination cases, and a wider, slightly wider interpretation in cases involving whistleblowing. Moving on to the more recent cases that I outlined at the start of this session, another further variation of the manipulator type cases was the recent case of Nickel and World Travel and Tourism Council from March of this year. And that centred on the required state of knowledge of the decision maker. Now, in that case, a qualifying disclosure had been made by email to an HR consultant that was engaged by the respondent employer. And in that case, whilst the HR consultant told the employer and ultimate decision maker about the concerns that had been raised in the email, the decision maker herself hadn't actually seen it and didn't know it in sufficient detail. Now, on appeal, the claimant had tried to argue that the original tribunal had fallen into error by inserting a new hurdle into section 103A of the Employment Rights Act. That's the protection against dismissal on the grounds of protected disclosure. Because section 103A simply states that an employee who is dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason was because of a protected disclosure. So in other words, what the claimant was trying to allege on appeal or suggest on appeal, knowledge of the ultimate decision maker wasn't necessarily required. Well, unsurprisingly, the Employment Appeal Tribunal disagreed and said that for employers to be fixed with liability, they have to know at least something about the substance of what is being alleged. No particular surprises in relation to that decision. Where things have got a little bit more complicated across the course of this year is in relation to how causation is dealt with in the context of whistleblowing detriment claims under Section 47B. We've already seen from the Supreme Court's decision in Duty that in whistleblowing dismissal claims, the court has a duty to penetrate through that invented reason in order to get to the real reason for dismissal. But the question that arose in William and Lewisham and Greenwich NHS Trust was whether the tribunal had a similar obligation to penetrate through, look at the question of motivation and influence in whistleblowing detriment cases. Now, in William, the EAT considered an earlier decision of the EAT and in Malik and Centros Securities. Now, in that case, in Malik, the claimant had argued that even if the individuals responsible for the detriment didn't know of the protected disclosures and couldn't have been materially influenced by them, the fact that other people were influencing them meant that the employer was fixed with liability. But in Malik, the then president of the Employment Tribunal said that that can't be right because that duty was only applicable to whistleblowing dismissal cases and not whistleblowing detriment cases. And so in William earlier this year, the EAT declined to find that Malik was manifestly wrong and maintained the position that duty, so this need to look beyond the mental processes of the decision maker themselves, didn't extend to whistleblowing detriment. So we're left in this rather unfortunate twilight zone because often in many of these cases that you deal with, that I deal with, claimants are advancing claims on both the basis of protected disclosure detriment and dismissal. So we potentially find ourselves in the unfortunate position where the Iago character, the motivation question, the reason why question, may well be dealt with differently depending on whether you're looking at whistleblowing detriment or whistleblowing dismissal. And then the final case that I just wanted to touch on in terms of updates is the one that I mentioned at the start, First Greater Western and Musa. And this arguably really has put the cat amongst the pigeons in a way. Interestingly, this is a case involving both victimisation because of the Protected Act and whistleblowing detriment, both of which relied on the same set of facts. Now, the Banquo's Ghost reference is in relation to one of the key protagonists in the First Greater Western case, an HR consultant who didn't in the end give evidence, but was found by the tribunal to have demonised the claimant because of his Protected Act and its protected disclosures. At first instance, the tribunal looked at the evidence and found that the respondent had a collective memory about the claimant. It was prejudicial and it permeated the approach of that HR manager. They noted that there was an email from the HR manager about the claimant that showed that there was a general negative view of him, which had found in its origins the claimant's earlier protected acts and protected disclosures. They found in favour of the claimant at first instance, and First Greater Western appealed on the basis of William and Malik. So they were saying you can only look at the motivation of the decision maker in cases involving protected disclosure detriment claims. The EAT disagreed with that particular view, and what they said is whilst vicarious liability had been added by the introduction through the Enterprise and Regulatory Reform Act, it didn't remove an employer's direct liability under Section 47B not to subject the claimant to detriment. And in this case, they concluded that the employer was responsible in light of all of its findings about this collective memory, this demonisation of the claimant, and the collective hostile memory that surrounded him. In considering the appeal in the EAT, Mr. Justice Kerr warned against an over-analysis of the causation question, and some of his comments you may well have sympathy with in relation to how the law has developed. He says, the cases have not developed in an orderly and uniform progression. Universal guiding principles are not easy to find. There are many variables. The causes of action may vary. The statutory wording varies. The class of potentially liable persons varies. The scope of vicarious liability varies. Importantly, whether a detriment is inflicted because of a protected act or a protected disclosure is ultimately a factual determination for the tribunal to make. Whether that makes matters any clearer, I'm not quite sure. But I've left you at the end of the handouts with the observations in Harvey's, which is the picture is now a complex one, and to state the obvious, we now need a Court of Appeal decision on it.